Brandon from WH Law. I'm going to talk about what creditors cannot do according to the FDCPA for debt collections. And there's a bunch of stuff. Some of these are general, so you can kind of understand what's going on, but they can't use threat of violence or other criminal means to harm a person, reputation, or property. They cannot use obscene or profane language. They cannot give a false representation that the debt collector represents a state or federal agency. Now, a lot of them won't do that, but where they kind of get gray with this is, the name of their company can be very misleading. Like, I'm calling with, what is some of the ones I've heard? Like, the Arkansas Special Program for Debt Relief or something like that. And just the name sounds like they are associated with it, but they never actually say they are part of Arkansas. So those are great, and you can still win on some of those. They can't give you any misleading information about the amount or the legal status of the debt. Now, this one gets interesting sometimes because, like, for instance, on a written contract in Arkansas, the statute of limitations is 5 years. On an oral contract, it's 3 years. Sometimes what will happen is they'll be calling to collect a debt after the statute of limitations is run. And so when they call you and tell you that you owe this money, it's actually false or misleading because you don't, because they can't enforce the debt because the statute of limitations is run. Another place that comes up is maybe the debt was discharged in bankruptcy. And so they called to collect the debt after the bankruptcy, and that's a false or misleading claim because you don't owe the debt anymore. So there's situations like that where they actually do violate misrepresenting that the debt is owed when it's not technically owed anymore. The implication that not paying the debt will end up with you'll be some sort of arrest or imprisonment, some sort of criminal activity. That's debt collection is always a civil action. So if they say anything about police, cops, sheriffs, or any kind of threatening thing, that is not true. Oh, I just thought about this. Another place where they falsely represent that a debt is owed, a lot of times they do that to another person. Like, say for instance, my daughter, who is not old enough to buy a car yet, but she bought a car, and I did not co-sign. Never co-sign. Never co-sign unless you fully expect to pay for a car. I know this is an aside, but I'm telling you this right now. I will co-sign for my daughter's first car. I will pay for it, and I will never do it again. I've seen too much of this stuff. But if they call me and say I did not co-sign, and my daughter's behind on her car, and they call me telling me I owe the money, that's also false and misleading because I don't owe the money. That happens a lot of times when people pass away. They'll call the family of the person who passed away trying to collect the debt, and you do not owe the debt, and that's false and misleading. So that's another piece. Calling too much. If they call you 30 times a day, that is annoying, and it's abusive, and so that's not allowed. And here's the big one that we've talked about several times: continue to contact you to collect the debt after they have received a cease communications notice. And that's that letter we talked about before. So that's why sending that letter is so important. Having proof you sent that letter is so important. So send that letter certified mail, because then we can also use that certified mail receipt as evidence in the lawsuit. So that's kind of the stuff that they are not allowed to do. Hope that helps. Thank you.